Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues, and today we have an interesting question from our video audience, and I like to read the question verbatim as it came in because a lot of times it's up to interpretation, and I like the viewing audience to hear the question because maybe you're interpreting it differently than I do. This one reads, "My ex is a psychopath. What can I do?" Well, it's a good question. I mean, he's your ex. That means you divorced him, so or her for that matter. So if you've done that, and that's a good step, right? If the question is meant to be like, because this person is a psychopath, I cannot accomplish parenting time. We cannot agree on things. We have joint custody, but joint doesn't work because my ex is a psychopath and there's no communicating with him or her. What do? That's a different story. Because in that scenario, if indeed you're dealing with someone who cannot be worked with, and your custody arrangement, for example, requires a working relationship, you've got to change that, right? So how do we change that? Well, the way you do it is you tell your lawyer that the joint situation isn't working because of reasons A, B, C, and D, and your lawyer will be in position to file a petition to change the custody on the basis that there's been a change in circumstances. And what's the change? Well, the change in circumstances is that before we had a working relationship, but lately this person has gone off the deep end and cannot be worked with in any normal way, so therefore a joint situation doesn't work. I need full custody. And you can make that presentation to the court. The court will conduct a hearing to determine whether or not there's been that change or whether or not the court should revisit this. And believe me, if you are right, if in fact there has been some sort of psychological breakdown where the other person really cannot be trusted or worked with in any way, the court may well view that as a danger to the situation, danger to the kids, etc., etc. And so therefore the court may very well say, you know what? We got to revisit the custody. But clearly there have to be significant proofs to establish that. If you have any questions about that, reach out and we'll be glad to help you out.